Hi everyone, my name is Janaína Penalva. I am a law professor at the University of Brasília, Brazil, and I am one of the co-editors of the book The Rights of Women in Comparative Constitutional Law. My colleagues Irene Spigno and Valentina Scotti and I have been dreaming with this book since we met in a conference of the International Association of Constitutional Law some years ago. In that moment, it was clear for us the importance of the discussion about women and gender rights, especially in the field of constitutional law. We therefore invited a group of professors and researchers to build a new research group named Gender and Constitution. The first project of this new research group was to write a book able to present a critical perspective of rights of women and to start to develop a constitutional perspective of women's rights under a feminist eyes. The book articles point out that the constitutional law, like other fields of law, was built on the false assumptions of gender neutrality. Without further ado, my colleagues will share now more details about the book.
As far as the contents and methodology we applied in the book, I would like to underline that the research behind the text was constructed with a common methodology in order to guarantee a high degree of homogeneity to achieve comparability of the national case studies collected in the book. In addition to the need to integrate this common methodology, it has been necessary for each author to take into special consideration some specific national features, which in some cases may have determined derogation from the common guidelines according to each case special need. The research focuses not only on formal constitutional provisions, but also measures the substantial level of gender equality achieved in each national case study under consideration, which is assessed through an analysis of the relevant gender-related constitutional provision and legislation, the participation of women in the institutional arena, and the constitutional interpretation made by constitutional judges on gender issues. In order to do this, authors were required to work on national chapters and to follow the same structure in each contribution, focusing first on the constitutional and legal context, secondly on the constitutional interpretation, and finally on the evaluation of the status of women's rights in each national experience under consideration. Each part was supported by one or more guiding questions. More specifically, in relation to the context, each author was required to take into account how gender equality and women's rights have been entrenched in national constitutions and how women have been contributed to this, especially highlighting whether gender equality has been achieved under the pressure of social movement or whether it has been the result of a top-down approach by governing elites, by international pressure, or, for example, by transitional post-war process. In the analysis, authors were required to pay special attention to the constitutional languages that has been used by constituent framers, both in countries whose language allows a gender distinction between sex and gender, but also countries where the implicit reference to a male attribution can be perceived from the text. Authors were asked also to avoid the traditional approach to legal history on the ground that it was developed from a male perspective, and to include in these sections a reference to intersectional issues such as colonialism or other national peculiarities deemed relevant to understanding gender issues in the country under study. In the research, authors were asked also to highlight any external influence that might have impinged on the condition of gender equality in the legal system and the presence of specific ordinary laws on gender-related issues, such as, for example, laws on violence against women, on work-family reconciliation, on parental leave, etc. But also the signing and ratification of specific international treaties on women's rights and the presence of women in the institutional arena. Authors were invited to include quantitative elements in the analysis, such as the existence of any constitutional provisions that explicitly mentioned or referred to gender equality or women's rights, the existence of ordinary laws tackling gender-related issues, and the quantitative data on the women presence in the last elected parliament, in the executive branch, and having a seat in the Supreme Constitutional Court. Finally, authors were invited to take into consideration possible external influences, implicit or explicit, voluntarily or imposed, horizontal or vertical, with specific preference to the ratification of the Convention on the Elimination of All Forms of Discrimination Against Women, the CEDAW, or the influence of any regional convention on women's rights. With specific reference to the second part of each contribution, constitutional interpretations, authors were guided to assess how constitutional judges protect gender equality and women's rights, with a specific focus on the main constitutional arguments, criteria, principles, or tests used by judges when dealing with the gender equality and women's rights. In this section, more specifically, authors were invited to consider the constitutional interpretation of gender equality in order to assess how judicial doctrine in each country is effectively involved in the protection women receive in each country under consideration. As the main objective of this book is to give an overview of the status of women's rights in different countries and regions of the world, we selected 13 national case studies, 6 from Europe, 4 from the Americas, 1 from Africa, and 2 from Asia, and these reflect the internal division of the book, focusing on the analysis of women's rights from a constitutional, legislative, and jurisprudential perspective. A major factor influencing the proposed structure is that in some areas, regional constitutionalism plays a very important role in establishing shared standards in the recognition, guaranteeing, and protection of fundamental human rights, and women's rights are no exception. Intuitively, it was not possible to extend the research to all jurisdictions worldwide. We are very aware of the significant impact that this absence has on the research, an absence, however, that leaves room for further studies in the future.
The comparison we realized in the book The Rights of Women in Comparative Constitutional Law underscores several elements. First, the advancements in the protection of gender equality are importantly connected to constitutional waves, and they observed the same kind of backlashes worldwide during periods of democratic regression. Second, but connected to the first point, the progressive consolidation of a universalistic approach to the protection of rights at the international level has importantly impinged on the emancipation of women and the recognition of gender equality at the constitutional level and at the level of constitutional interpretation. Third, despite the existence of several legal measures for promoting gender equality and protecting from gender-based violence, the effectiveness of these measures is connected to the commitment of political forces to a gender equality agenda. This entails not only the approval of norms, but also the constant supervision of their enactment and implementation and the training to their respect for all the involved operators. Fourth and final, all the chapters underscored that there still exists worldwide a debate on how the reproductive functions of women should be regulated, involving ethical issues often instrumentalized to achieve their commodification. The appraisal, we could realize, therefore, tells us that all the countries analyzed have approved the policies to enhance gender equality at multiple levels, though some of them also give us pictures of success stories of resistance groups aiming at retaining family mainstreaming and revamping gender complementarity theories. Even where the opposition to gender equality is failing, important shortcomings with regard to the implementation of enacted policies are occurring. The book therefore confirms the need to continue researching in this field, taking into consideration the impact on gender equality of often neglected aspects such as the state architecture, the economic situation of countries, and the commitment of social movements. In our concluding remarks, finally, we, maybe ambitiously, proposed some possible solution for the weaknesses on the implementation of gender equality, such as the establishment of stable legislative and executive bodies for the coordination between state actors and social forces, and the adoption of a gender mainstreaming approach to policy making, which will keep the burden of the cultural evolution on the state instead of moving it on an undefined actor, for instance, to the introduction of the gender impact assessment and of the gender responsible budget. Expressing gratitude to all the authors for their invaluable support throughout the elaboration of the book, also on behalf of the colleagues who edited the book with me, I want to thank you for your attention, and we really hope you will enjoy the book.